She's asking people to carry her. She's giving you just a little. Gladys night, everybody. Ladies and gentlemen, you see this right here? This is a preemptory challenge. This is designed for arbitrators only. Okay, it won't help you if you ain't an arbitrator. We have a lot of individuals who started private arbitration organizations out there and who have been queasy about asking me for assistance. So what we've done, ladies and gentlemen, we put together a document that challenges the court's jurisdiction to call an arbitrator in to ask questions other than what's here. So this is what the arbitrator says. Hey, I received this, I did this, and I was to determine whether or not a contract existed. I was to determine whether or not an arbitration clause was associated with the contract. I determined. Okay? Then it goes on to say whether or not the contract was willful and or workable. Based upon the information presented, I determined that there was a prior agreement. And he goes over all of the steps. The arbitrator, or she. Hold on now. Want y'all to understand, it ain't just a little bit of information. It's a lot of bit of information. Because this case brings to mind these insights concerning government. And it explains about the private trust. That's why you're coming in as a beneficiary. Okay? Oh, I'm sorry. I still got the voice recognition on. That ain't gonna be good, y'all. Y'all just gotta hold on a second. That Voice America Mauritian is gonna mess up a lot of stuff. Ladies and gentlemen, it was turned off. But the problem with it is I'll go back and make sure because I don't have to save the document because it's already saved. I already saved it before starting the video. All right. Preemptory jurisdictional challenge. Ladies and gentlemen, a person has a duty. An arbitrator acts within the bounds of their common law tutorial. Tutorial! This is my word. I created that word. Okay? Go ahead, try looking it up and see what you find. I made it up. My word! Because they have a duty. They have rights associated with that duty. And the rights associated with the duties of an arbitrator is immunity. As long as they're performing a judicial act, so the arbitrator is highlighting that they performed a judicial act. The entire thing is judicial. They also document that the person applied for consideration of their document. Since the courts want to call it a document, well, the arbitrator lets them know, hey, I took a look at the document and I saw that it was a contract. It had all the elements of a contract. I determined this. I determined that under my judicial authority. Now, hold on now. Gotta let y'all know where we're going. Do you know that arbitrators, would you get on out of here? All right, ladies and gentlemen, did you know that arbitrators have the same ability and the same judicial immunity as a judge? That's right. An arbitrator and a judge carry the same immunity. So what gives a judge the right to determine whether an arbitrator is an arbitrator or not an arbitrator? They sit in the very same position. Do you guys know that doctors cannot overrule another doctor? Because they have the same capacity. They have to be an administrative board that has position of oversight. Judges don't have oversight over arbitration awards. It says the court. Okay? It does not say the judge. But the judge represents the court. Doesn't matter if the judge represents the court. They both have the same arbitral immunity. So because they have the same arbitral immunity, they're stuck. So this is saying, hey, if we have the same immunity and you're ignoring the law and ignoring my immunity, you cannot make a determination as to whether or not I have immunity. What you can do is send this to the appeals court because that's the proper jurisdiction. for any questions as to my immunity. That's how you take care of their stupidity. Okay? As noted above, the request for arbitral disposition constitutes a contract between the arbitrator and the party making the request. Thus, there is the authority for the arbitrator to act inasmuch at least one of the parties, inasmuch on at least one of the parties' behalf. Okay? That's what that says. So that's for our arbitrators. This document for anybody who acts as an arbitrator. Somebody want to call you in the court, they can only ask you questions regarding the specifics as to how you came to your conclusion. They have nothing to ask you. They can only ask if you followed the rules, and that's why this only states what the rules require. Okay? That's done. Do you want to say no? Okay. Now, Alford and Long. I don't know who Alford and Long is. I know, y'all, that there's some company out there called Alford and Long. I have no idea where it is, but I know it exists. And then Ralph Walton? Man, it was supposed to be Ralph Waldo, but Waldo, who knows where he is? Marco! I'm sorry. Anyway, people, my computer has froze for just a second, so let me unfreeze it. Y'all give me 1 second, all right? I'll be right back. Now, ladies and gentlemen, this document right here. Get on out of here, Microsoft. Microsoft getting on my nerves, y'all. It's stopping me from doing what I need to do. I'm going to slap Microsoft in the back of his head. This is that notification thing. It's not really causing a problem. I can get around it. Ladies and gentlemen, this is for those of you who are going into court, and you can call it a motion for reconsideration if you want to. However, many people are having attorneys come at them saying, hey, we didn't attend y'all hearing, but we gonna ask the court to dismiss your junk and to vacate it. Ladies and gentlemen, so that most of you can understand, there is nothing in the Federal Arbitration Act under Section 10 and 11 that permits, and it's technically the United States Arbitration Act, not the Federal Arbitration Act. Federal Arbitration Act is the generic name that was eventually given it, but the official name was the United States Arbitration Act. It also does say Federal Arbitration Act, but United States Arbitration Act is more appropriate. Okay, now that we get this, ladies and gentlemen, so long as the idiots don't attend the hearing, many of them have been trying to get your stuff dismissed, kicked out, vacated. They cannot ask for a vacating of the award and ask for sanctions and ask for declaratory judgment. It's not permitted. Federal Arbitration Act only allows for a motion to vacate, a motion for modification, or a motion for correcting. They don't get to ask for anything else other than that. It's a very limited grounds for which they can get the award vacated. It's all spelled out in section number 10, the very first part of that section. Nothing in there says anything about vacating or sanctions. So if you've had a court issue sanctions or vacating of your award, the case law is here, run with it. The argument is here, run with it. You identify yourself as a beneficiary of the local, county, state trust, and the federal trust. Okay? Rebutting their theoretical presumptions. Now, ladies and gentlemen, there was a gentleman. His name is Mr. Williams. I ran over a case by Mr. Williams today, and Mr. Williams brought up all of the points. The only thing Mr. Williams did not do is say it appears that the court is operating off presumption. It appears that the court is doing this. It appears the court is doing that. But because he went straightforward like I do, they ignored him. He brought up everything he needed to bring up, but he needed to challenge their presumptions, and he didn't challenge it. He didn't form it in a question. He made it statements. Ladies and gentlemen, they don't recognize statements in the courts. Okay? Just the way it is. All right. Ladies and gentlemen, this has all the case law you need to let you know that they cannot go past the 90-day limit. If you had an award vacated after 90 days. Ladies and gentlemen, that was illegal. Go back in, ask for a reconsideration, and appeal it. These are all the cases. These are all recent cases. 2019, 2019, 2012. These are recent cases. Okay? And the fact that if they brought a claim based upon the so-called statute, the code, you put the information here that what the code means and what it don't mean, that it is not law. Okay, this is from the website of the United States Congress, and there it is right there. You put it right there, and I just put my mouse over it. Wait, hold on, it's supposed to be highlighting. Come on now, it don't. There it is right there. Okay, the codes and everything. This is a hyperlink document. It's including hyperlinks. Ladies and gentlemen, you put your information in here, but the plaintiff appear to fail in stating a valid claim. You'll put appeared with an ED because the case is already over. Okay? Then we highlight that it must be brought within the jurisdiction wherein the award was made. It cannot be brought without the jurisdiction. A motion to vacate may only be had within. Then we put the definition of within, since the act itself does not supply the definition. The statute, pay attention, the statute, because it does not define within, then what the law says is we must resort to the ordinary meaning of the word. So we put the ordinary meaning of the word. Okay? It's a limiting word that has been referred to or in the contract within it wherein it is stated. Give me 1 second, y'all. I gotta answer this. This is Home Depot. Stupid phone. Ladies and gentlemen, I am in the process of getting ready to go out and correct something that is damaged outside, but I'm going to finish talking to you guys about those of you who've had arbitrations kicked out of the courts because they've said this or they said that. Ladies and gentlemen, that's what this document is designed for. If you have an arbitration award that you need to get confirmed, that's what this document is designed for. You're not submitting to anybody's jurisdiction. You're basically letting them know you don't have any more excuses, Mr. Court. The Supreme Court made this quite clear. This is what it says. The award does not appear to have been issued in the district of, for this particular case, Mississippi. So what you guys are going to have to do, this is not up yet. I'm going to highlight this because Mississippi is ground zero. That's where they've been doing a lot of the attacks with the backwards, ignorant, moronic judges of the district court there. Okay, they're just following a script like all the other courts. They've come together and they've decided they want to attack a particular arbitration association, which the arbitration association has not issued a single award yet. Anyway, thus, the court appears to be absent of jurisdiction. The court can only vacate an award in the jurisdiction wherein the award was issued. That's why we deal with the definition of wherein or within. To entertain an application for an additional point of contention, the American Supreme Court has stated that all courts must follow their lead, the United States Supreme Court. We must interpret the act as written, not the code. And the act states that y'all needs to, like I said, put your state here. That's why it's in red. As a matter of fact, let me copy that. Copy that. I copy that. Oh, I copied that, boy. Oh, I sure did copy that yesterday. I don't copy it today. Now, V, Mississippi. Now we gon' format highlight. Just that simple. Format, highlight. Now, we want special. And what we going to do special? What we going to do special? I think we're going to leave it the way it is. We ain't going to be special. Okay? But that's what we're going to do. We're going to highlight it. And there you go. Every time it says Mississippi, it's going to be highlighted. Okay? Now, that's so you will know. Got one more thing we going to highlight. See, this says no highlight. Nope. We got to highlight it. And then we're going to do one more thing. No, let's make sure it's this one. Okay, make sure, see, yeah, this one, we don't want this one highlighted. We want no formatting on that one up there. Nah, we want to, okay, we're going to do it that way. All right, then we can go back here, format, and then we can go right here. And then we're going to go, not that one, this one right here. See that right there? That's what we're going to do. We're going to bold it and italicizing it. And we're going to hit enter. Now, you're going to have to change that, homies and homegirls. Okay? It's going to be 6. C6. All replaced. All right. Mississippi. So, you're going to have to change it. Put your state there. Notice this, ladies and gentlemen, because a lot of people keep saying that, you know, EON, he does all this talking, but he won't help nobody. The Ninth Circuit has held that a motion to vacate an arbitration award must be filed within the district wherein the arbitration award was made. EON didn't write this, people. This was the Ninth Circuit Court. Pay attention. It is accordingly evident that following the Ninth Circuit, the proper venue in which to move to vacate the present arbitration award is in California. This is not me saying this, is the court saying it, where the entire case may be dealt with expeditiously, because the plaintiff's motion to vacate the arbitration award must be brought in was brought in an improper venue. Recognition motion to dismiss. The action must be granted. I didn't say that, ladies and gentlemen. This is Connecticut that made that decision. Connecticut that made that decision. I didn't make this decision, ladies and gentlemen. There's a 1985 case. Some courts have attempted to lump the confirmation section with vacating and modification section of the United States Arbitration Act. Ladies and gentlemen, what the courts have done, they say since the Federal Arbitration Act under the confirmation section refers to vacating an award, then it can be in any jurisdiction. Sorry, homie. Unless the award is vacated as prescribed in the following sections, is what the 9th section says. So it says unless. So it's restrictive in application of vacating. It's by reference and not by root. That's what we're saying here. So we says unless, and we give the definition for unless because the act itself does not give the definition, so we must rely on the ordinary definition in order to come to a conclusion. Because the Supreme Court said we must interpret the act as written, not as conjured up on presumption. So when Congress utilized similar tone, it was stating that this only applies if this is not at issue. Only in certain circumstances would you consider this. That's what Congress was saying. Not because we mentioned the exception here, the entire exception may be considered. This is precisely what Archer decision eliminated. That's what the Supreme Court said. Notice this. The adding of exceptions to the code. The act does not contain a whatever venue bargain hunting forum. A disgruntled party elects groundless exception, and we are not at liberty to rewrite the statute passed by Congress and signed by the president. Individuals, many of you didn't know, but the courts have been making exceptions to the Federal Arbitration Act, the United States Arbitration Act, by allowing individuals to ask for declaratory injunction, declaratory and injunction and sanctions. Nowhere in the Arbitration Act does it allow that to happen along with a motion to vacate. Okay, these are all separate procedures, separate motions. You cannot include them in a motion for vacator or motion to vacate. The exception is limited. The act does not include sanctions and declaratory judgment in the Section 10 motion to vacate. Only those issues are what they can vacate under. Nothing else. Okay, ladies and gentlemen. Oh, that's right. If you go back and look at the case, arguing that the dispute was not subject to arbitration because Archer and White complaint sought injunctive relief, at least in part. According to Archer and White, the parties' contract barred arbitration of disputes where the plaintiff sought injunctive relief. Even if only in part, the Court of Appeals have determined that the court, rather than the arbitrator, should decide the threshold arbitrability question if, under the contract, the argument for arbitration is wholly groundless. Those courts have reasoned that the wholly groundless exception enables the courts to block frivolous attempts to transfer disputes from one court system or from the court system to arbitration. We conclude that the wholly groundless exception is inconsistent with the text of the act and with our precedents. We must interpret the act as written, and the act in turn requires that we interpret the contract as written. In other words, there is no injunctive relief section to the vacator section. That's what they're saying. Now, we've added that information. We put it in a condensed format so that you guys, all you got to do is make this fit your situation. Prior contract, duty to respond, waiver, right to consent. Ladies and gentlemen, I didn't say this. I'm about to read to you a law that they already have. We put the Bradley Christopher Stark stuff there. Okay? We put that stuff there purposely. Let's see, is this the plaintiff return of the modified agreement conditional acceptance? The plaintiff's return of the modified agreement constituted a counteroffer. I didn't say that. The court said this. The defendant's attorney letter rejected the counteroffer. See, modified agreement, that's called a counteroffer, people, or a conditional acceptance. However, that same letter also contained a renewal of the original offer. While silence itself is not an acceptance of absence of a duty to speak, a duty to speak is imperative as a matter of law, where conduct accompanied by silence, by not speaking when you have a duty to speak, that's a conduct, would be deceptive and beguiling. If they have a duty to speak, they must speak. A party may waive its right to contested arbitration by failing to timely raise an objection. Oh, we ain't attending that arbitration. We object. They don't do that, they ain't got no case. So many of you, your arbitrations were dismissed unlawfully. We are getting ready to go before the Supreme Court. I am letting everybody and their grandmama know. No attorney general can step in front of me on this one. We're getting ready to go before the Supreme Court, and we're getting ready to go after having each one of those arbitration decisions overturned. You all need to just be patient with me, because that's my December, November pledge. I did foreclosure like I told y'all I would. Now it's time to help these arbitration people. You feels me? By the way, diversity of citizenship. When they want to vacate an award outside the jurisdiction that it was supposed to be had, there's no diversity of citizenship. You don't have the right to call the arbitrator over there. You have no jurisdiction over the arbitrator because the act doesn't give you jurisdiction over the arbitrator. The award was not issued in your district, in your jurisdiction. Sorry, lack jurisdiction. That's what you all need to be saying. That's what this document says. A motion for summary judgment, which is only appropriate in civil action, is not permissible in a proceeding to vacate an arbitration award. So asking for declaratory judgment or summary judgment, they don't get to do that. A motion to vacate is an application, not a court action. So when they start calling you litigants in a motion to vacate proceeding like PennyMac did with us, and we're going after PennyMac, to this day, the court was supposed to have a bench trial on August 2nd. To this day, none of the parties have received a decision from the court. Because why? The court's looking for a way out and it ain't got one. Stupid mother. I apologize, y'all. Y'all know how's it is. Now we bring up the Bradley Christopher Stark. Attaches a copy of Bradley Christopher Stark Act to this presentment, enacted by Congress, evidencing positive law, because it was enacted by Congress. I bound this court to the principles and the legal procedures performed by Congress in enacting this law. The Bradley Christopher Stark Act is a law. It's a private law, but it's still a law. But we're going by the principles of the law and the actual procedure that Congress went about in enacting the law, which was passed by a 2/3 majority, and not only by the House, but the United States Senate, overriding a presidential veto. The matter to overcome the provisions of this act of Congress have never been repealed, revisited, revoked, or viewed by any court as unconstitutional. And until such times, the principles associated thereto are deemed to be binding upon all jurisdictions within the United States of America. And because the contract involves an arbitration clause in the United States Arbitration Act, have been accepted by the civilized nations of the world. It is binding upon and within those jurisdictions in which international provisions of the United States Arbitration Act apply, as deemed applicable by the United States Congress, United Nations, and international participants in the process. Basically, we're saying it doesn't matter where you go. The principles of the Bradley Christopher Stark Act, sending a contract to somebody, having them default on the contract, that's all you need. Now look, ladies and gentlemen, the law says that your affidavits must be verified. Pay attention to the verification. I do hereby attest that the aforementioned is wholly accurate. Based upon my belief in God, I say that such is not only witnessed by God, but that the information provided is either based on first-hand information and or court opinion in line with the truth. And to the extent possible, I declare under penalty of divine retribution, evidencing my right to practice my religion of my choice, that such is the case on this May 9th, 2022. You got to correct that date. So help me God, if it is found to be otherwise. Now, what I got to do, we got to start that program, because y'all know my routine, putting documents up. Now, I want y'all to pay attention to this. Pay attention. Ralph Walton, beneficiary and underwriter. And you autograph underneath the line. Sign under your name. Remove these words when finished. Delete it. Okay? Sign underneath your name. Don't sign above your name. You want to be the underwriter of your document. You feel me? I feel you, homie. Good. Now, the only thing I need to do, you see this right here? Up, up, and away! I needed to move that up. Do you know why I needed to move that up, y'all? Move it on up to the east side, to a deluxe apartment in the sky. The reason why I had to move it up, because it was too far down, and it would have made one extra page. This document with the Bradley Christopher Stark Act attached. Bradley Christopher Stark Act attached. You feel me? With the Bradley Christopher Stark Act attached to the document, ladies and gentlemen, I'm going to let it install new version. I should have waited, but it's been wanting to install this new version for quite some time. So I'm going to let it do what it do, you know. And then I'm going to upload it. We're going to put this, oh God, I don't know what file I'm going to put it in, ladies and gentlemen. We can't put it in the mortgage file because that doesn't deal with arbitrations. So I'm going to create an arbitration folder. No, I'm going to pause you guys. Once I get that program updated, then I'll come back and let you guys know what folder it's in. So 1 second, y'all. Okay, ladies and gentlemen, we are going into this directory right here called the PDF directory. We will be there shortly. I need you guys to, I don't know if it's going to let me. So hold on 1 second. Look at that. It had to reconnect. I don't know why it's reconnected. It's retrieving the directory. Give it a second. We'll be right back. Well, literally, it was a second as I'm clicking. It's keep selecting. You know what? I got to figure out which directory. How about freedom? I don't see anything in here about arbitration. And I was going to create a folder called arbitration, but I figured, why would we do that? What we're going to do is we're going to come up to the top, a legal understanding. That seems to be the very best place to get up in there. We going to get up in there, y'all. All up in there. That's what we going to do. So, ladies and gentlemen, we going to be going here. And we got sample documents. Come on now, both of you. And we're going to transfer these and we're going to drag and drop. So it's going to be in a legal understanding. The very first folder. Number 1, a legal understanding. The documents are there. This is what I do. Ladies and gentlemen, I want you all to know this because you guys won't understand it otherwise. I've been working on the second document, the first one that I showed you. Been working on that since 8 o'clock this morning. The document, the one that I showed you, the second document that I showed you, the last document that you saw, I've been working on that document all day yesterday from about 8 o'clock in the morning till 6 o'clock in the evening. It's taking longer because I'm trying to be more precise with words and trying to get around loopholes. I did that for 2 current cases, but I decided to make it in such a way that it could apply to all of you. So what I am suggesting, a legal understanding, is the folder that it's in. You're disconnecting from the server? Well, fine, disconnect. What I am trying to do for the rest of you is give you something to fight with. A lot of you are scared of arbitration because you want money right now, and you don't even realize the tax credits. You don't realize that even when the economy falters, everybody wants to put their money in Bitcoin. Bitcoin goes up and down. People, your tax credits don't. They're dollar for dollar. And even if it's a percentage, pay attention to where you stand. Can tax credits be sold? You better believe they can be. And because they can be sold, guess what that do for y'all? It gives you some value. It's better than being invested in real estate. You just have to understand how to use your tax credits. We still got more videos to put up about that. Take care of yourselves, everyone. Those of you who have arbitrations that you have not done, the Q packers, you don't lose your value. You're going to get tax credits for your Q packs, but you would get twice as much if you were to have gotten the arbitration done. Don't worry about the judge denying your confirmation. The more they deny, the more we will go to the Supreme Court. I need a class. That's why I'm waiting. I need enough to go before the Supreme Court as a class. We have to prove a variety of vast demographic. We have to show that this is affecting the entire United States and not just a couple of states. You guys got to understand why the Supreme Court hears cases, what cases they're required to hear. Okay? That's what we're doing. The idea is to change this whole script. They haven't changed the Federal Arbitration Act because they can't. They changed the Federal Arbitration Act. It affects all the other corporations, just as I told you. Oh, he had a plan, Mama. He knew what he was doing from the very beginning. You better believe I did. I gotta go, ladies and gentlemen. I do hope everything works well with all of you. Take care of yourselves. Stay out of trouble. And I'll keep it coming for as long as I can. I really, y'all know the time of year. Those of you who've been around and been watching my videos, y'all know how I am this time of year, how things start to slow down for me. During the summer, I got all kind of energy. During the winter, things slow down. Just like I was about to hit the X, and that would have killed the whole video. I gotta hit this red button. So gotta go, y'all. That's how tired I is. Gotta go. Bye-bye. Adios, sayonara, senorita. Senorita, arrivederci.